Workplace discipline is essential to maintaining order and fairness. But in Vietnam, it's not enough to simply warn or fire an employee. The labor code treats workplace discipline as a legal process, not a managerial choice. Every warning, demotion, or dismissal must follow prescribed procedures, timelines, and documentation requirements. When companies skip these steps, even justified actions can be ruled unlawful. For foreign employers, understanding and following the disciplinary process correctly is the difference between maintaining control and losing a dispute. Workplace discipline in Vietnam is governed by Vietnam's labor code and its guiding regulations on labor discipline. These laws define the types of disciplinary measures employers may apply. 1. Reprimand. 2. Deferral of salary increase for up to 6 months. 3. Demotion. 4. Dismissal, the most severe form. However, these measures can only be enforced if the misconduct is clearly defined in the company's internal labor rules, ILRs, and those ILRs must be registered with the competent labor authority. Without registered ILRs, any disciplinary action, even dismissal for theft, is automatically invalid under Vietnamese law. Step 1. Establishing the violation. The disciplinary process begins the moment misconduct is detected. Employers must immediately record the incident through written reports, photos, videos, or witness statements. The goal is to create a factual foundation. Each incident must be linked to a specific clause in the company's registered ILRs or labor contract. For example, being late once may not warrant action, but repeated tardiness defined as serious misconduct under ILRs does. Documentation from the start protects the employer's right to act later. Step 2. Conducting the investigation. After recording the incident, the employer should conduct an internal investigation to verify the facts. This may include reviewing evidence, interviewing witnesses, and requesting the employee's written explanation. If the misconduct is serious, the employer may temporarily suspend the employee from work in accordance with the labor code while the investigation continues. Such suspension must be limited in duration, properly documented, and issued in writing, stating the reason and conditions of suspension. Suspension is a procedural measure, not a disciplinary penalty, and must never be used as a substitute for dismissal. Before imposing any disciplinary measure, the employer must organize a disciplinary meeting. At least 5 working days before the meeting, the company must issue a written notice to the employee, the employee's representative, if any, the company's employee representative organization. The notice must clearly state the time, place, and purpose of the meeting and be delivered in a manner that allows the employer to demonstrate proper notification. Failure to provide proper notice or sufficient preparation time may invalidate the disciplinary decision, regardless of the seriousness of the misconduct. The disciplinary meeting is a formal legal procedure and must follow the order prescribed by Vietnamese labor law. Required participants include the employer's authorized representative, the employee, and the employee representative organization at the workplace, if established. During the meeting, the employer presents evidence, and the employee must be given a full opportunity to explain and defend themselves. Meeting minutes must accurately record all discussions, opinions, and conclusions, and must be signed by all required participants. These minutes are critical evidence of procedural compliance. Without properly prepared and signed minutes, even a justified disciplinary decision may be overturned by labor inspectors or courts. After the meeting, the employer must issue a written disciplinary decision. This decision must include the employee's full name and position, description of the violation, legal basis, specific article in the ILRs and labor code, form of discipline and effective date, signatures of the employer's authorized representatives. The decision should be bilingual for FDI companies and delivered directly to the employee. A copy must be filed in HR records for at least 5 years. Without a valid written decision, no disciplinary measure is legally enforceable. Vietnam's labor code imposes strict disciplinary timeframes. Employers must impose discipline within 6 months of the violation, or 12 months if discovered after an internal audit. Miss these deadlines, and the right to discipline expires. Employers must also avoid disciplining employees who are on sick leave, maternity leave, or temporary suspension. Violating these humanitarian rules can turn a lawful action into a wrongful dismissal claim. Timeliness, like documentation, is non-negotiable. If the disciplinary action involves demotion, salary delay, or dismissal, employers must complete all related administrative steps promptly. This includes updating HR files, payroll adjustments, and insurance contributions. For dismissal cases, final payments, salary, unused leave, and benefits must be completed within 14 working days of termination. LTS law recommends conducting a post-disciplinary review to ensure that all steps, documents, and settlements comply with the Labor Code. Documentation tips for employers. 1. Always maintain written records of every step, from the incident report to the disciplinary decision. 2. Ensure that all disciplinary documents have a legally valid Vietnamese version. Bilingual versions are strongly recommended for foreign-invested companies. 3. Keep both digital and hard copies with employee signatures or proof of delivery. 4. Reference the exact internal labor rule clause for every disciplinary action. 5. Ensure your internal labor rules are up to date and properly registered. Outdated or unregistered rules are unenforceable. 6. Documentation is your strongest legal defense. Without it, even the most justified disciplinary action can collapse during inspection or dispute resolution. Common compliance failures include applying disciplinary actions verbally, using English-only decisions or templates, missing legal deadlines, having unauthorized managers sign decisions, skipping employee or union notification, failing to notify the employee or the employee representative organization at the workplace, if established. These errors expose employers to reinstatement orders and penalties. Prevention starts with consistent documentation and legal oversight. A Japanese manufacturing company in Binh Duong disciplined a worker for repeated tardiness. They documented every incident, issued written warnings, and followed the full legal procedure. When the employee filed a complaint, the Department of Home Affairs found the process compliant and upheld the decision. The company avoided penalties and reinforced its management authority. Proper documentation turned potential liability into legal protection. At LTS Law, we provide comprehensive support for workplace discipline management. Our bilingual lawyers draft compliant ILRs, prepare disciplinary notices and meeting minutes, and train HR teams to apply discipline lawfully. We also conduct audits to ensure your procedures align with Vietnamese regulations. For foreign-invested enterprises, we customize bilingual documentation to fit both global policies and local compliance standards. In Vietnam, lawful discipline equals documented discipline. Every warning or dismissal must follow the law, not just policy. Don't wait until a dispute exposes your company's procedural gaps. Contact LTS Law today to review your disciplinary process, update your internal labor rules, and implement a compliant documentation system. Protect your company's authority, maintain fairness, and handle workplace discipline the legal way, with LTS Law by your side.